Dear colleagues, I hope that you hear me well. Good morning, Mr. Candidate, and I would like to greet also the members of the public who watch us live. Today, the advisory group of experts has gathered in full composition to conduct the interview with the candidate for the position of a judge of the Constitutional Court of Ukraine, Mr. Yuriy Barabash. Mr. Barabash serves as professor, constitutional law chair, vice rector for research and pedagogical work and strategic development of Yaroslav Mudry National Law University. He was admitted to the competitive selection process by the Parliament of Ukraine, Verkhovna Rada. I will pass the floor now to Secretary of the Advisory Group of Experts, Mr. Yaroslav Romaniuk, who will moderate this interview. Yaroslav, the floor is yours.
Дякую, пане голово.
Thank you, Mr. Chairman. Good morning, Mr. Yuriy. Good morning, everyone. Mr. Yuriy, there are present AGE Chairman Alesh Zalar, and he will be online with us. And physically, we have here Miss Hanna Sochotska, Miss Maureen O'Connor, Miss Oksana Vasilchenko, and Deputy Member Vasil Shakun, and the Miss Natalia Kuznetsova is recused. That's why we have deputy member instead of her. I would like also to draw your attention to the fact that the AG members deputy are here. Mr. Barrett, Mr. Zubik, and Mr. Kuzmenko, and me, AG Secretary Yaroslav Romaniuk. So we have time and we have studied information about yourself. We're really grateful for your communication with the AGE. You obtained our questions, you provided answers to them, and it helped us to form general picture. There are a lot of positive things in the information obtained from you, but there are also some moments that we would like to clarify. And this interview is aimed at clarification of some moments that seem to us a bit doubtful regarding high moral qualities that are required for the position of the judge of the Constitutional Court of Ukraine. So now you will have possibility to answer the questions, to clarify any doubts. Also, I would like to say that according to the methodology, we wouldn't take into consideration documents that maybe you would like to present us today if you haven't provided them earlier. So the documents presented today won't be taken into consideration. However, the advisory group may make an exception if it determines that such an exception is justified. I also would like to say that there is the fact that the interview is being recorded and streamed live on the AGE resources as well as the Constitutional Court of Ukraine. I call upon the AGE members and the candidate to limit the use of sensitive data and limited access information on live air. If this happens, we will terminate the live streaming and we will discuss it in private. Also, I would like to draw your attention to the fact that the duration of the interview is approximately 1 hour. The time limit for the response to a question is 3 minutes. We ask you to be concise. At the end of the interview, you will have opportunity to make a short closing statement, up to 5 minutes. So, we are ready to start our interview. And I will ask you the first question. So, from May 5th, 2022 to May 5th, 2024, your wife had the right to use a vehicle, Porsche Cayenne. Please tell us about this car. In particular, on what basis did your wife acquire the right? And what is the purpose of this acquired right? Good morning, respectful members of the AGE. I heard that my wife has the right to use the vehicle, but this car belongs to the brother of my wife, and I retain him as my brother. The power of attorney was issued after the full-scale invasion of Russian Federation in Ukraine on the May 5th, 2022. I presented this information beforehand, and it was my decision to inform you about it. On the 8th of May, on request of her brother, my wife, through the checkpoint Porobny Seret, crossed the border. She transferred this car to another person, and then she returned to Ukraine without a vehicle. Okay, so why there was a need to provide power of attorney for 2 years when there was a request just to transfer the vehicle from Ukraine? As my close people explained it to me, it was offered by the notary. But we can also check out and vet all the information whether the car was used. Because you know that after the 8th of May 2022, the car didn't cross the border, didn't enter the Ukraine. So, Mr. Yuriy, were you aware of the fact that your wife acquired this right of use? I understand, because we talk about the article number 46, due to the law on prevention of corruption, we talk about the declaration, but I know that this car was in use by my wife only during 1 day, so it was less than 183 days that are stated by the law. And this car wasn't used by my car in the last day of the accounting period. Yes, you understood well why we asked you this question. And we have also the question, why is the information regarding your wife's right to use the car Porsche Cayenne missing in your declaration, especially for the declaration 2022? As far as I understand, you think that if your wife used this automobile less than 183 days per year, you didn't need to declare it. According to the legislation in vigor, we can use the car on the territory of Ukraine even without the power of attorney. So I decided to declare only those vehicles that were used by my family at the last day of the declaration submission or during 183 days. But the power of attorney was issued in name of your wife, and she could use it during all the year, and it should have been declared in the declaration. I perceive this law as it is stated, and I reflect in declaration everything that is in reality. Thank you so much. The next question will about the automobile Toyota Camry. There is similar situation. Also, May 11th, 2022, the father of your wife provided the right to use for this car. Tell us, please, what was the goal to provide such power of attorney, how the wife used this automobile, and you understand why this right of use wasn't reflected in the 2022 declaration. So, I would like to say, we live near our family and the family of my father-in-law, who is my second father. So, and near we have garage. And on Friday, a drone was launched in the nearby place. I will explain. I will explain that I should be concise, but please let me explain. So, neither my car, neither our car, nor my father-in-law car was affected. So we decided to issue this power of attorney at the beginning of war because we didn't know what would be in future. And there was also the right not only to use but to sell it. And this car was used by my father-in-law, not by me. And I told you about the Friday's drone attack because we can't foresee what will happen tomorrow. It means that we have only Ford Hugo in my family. That is reflected in my declaration. Thank you so much. It is clear. And the answer is the same why this car isn't reflected in your declaration. Yes, because it wasn't used by my wife or me. The next question will be about the shares of the private joint stock company, Scientific and Research Institute for Radio Engineering Measuring. So tell us, please, how many shares are owned by your wife? Okay, so I informed you that I found this error. I don't know about this company. I know that there is statute capital 10 million, and my beloved wife has in her possession 0.0025. So this is 2 millisimoles of percent of this company. There was an error because all the information was taken from the registration and recording in the family. I found out this mistake, and I know that in 2020 the legislation was changed, and now, as for new algorithm, we should present not the total amount of all the shares, but the cost of one share. So now it seems that she has 900 shares with relevant costs. So it is a technical error. I found out it myself, and we talk about 2 millisimoles of 1% of shares. Let me clarify. In 2016, 2017, 2018, 2019, 2020, 2021, and 22, you indicated that your wife possesses 4,780 shares, but generally it is 956. And the reason why you stated it in with the error in 2016, and then this technical error just migrated from one to the second declaration, and why you never verified the accuracy of such information in official documents or sources. Well, it's not so easy to do it. For example, if I hadn't indicated this by myself, I don't think that the AGE would have found this information. I think that we would have done it in any case. So you say this is a technical error. So instead of putting the cost of one share in the declaration, that is 25 hryvnia cents, you indicated the total amount of all the shares, 239 hryvnias. Yes, because the algorithm was changed and I didn't pay attention to it. Since 2020, we should indicate and declare the cost of one share. Okay. The next question will regard the copyright to the educational and electronic and information complex in the constitutional law of Ukraine. Do you possess the copyright to this educational electronic information complex? Yes, this is non-liquid complex. I am a co-author since 212, but actually it doesn't exist anymore. So you are co-author. Yes, there are my colleagues who also were authors. So why you don't reflect it in the declaration? In the declaration, you indicate it as your private ownership. So this asset currently has another status. This complex contains methodical recommendations in the platform Moodle and also some lectures and exercises. It's very difficult for me to find out why the responsible people in charge of our academy decided to register copyright. But starting since 212, this material has disappeared. And now I am just possess the document, a sheet of paper, where it is written that I am holder of the copyright. Yes, but we are talking about declaration, so you declare it as you as unique holder, but you say that there are co-holders. This is a technical error. I just accent and stress out my revenues and my information. Okay, it makes sense. So there are English-speaking members that will ask you questions in English. If you want, you can use the headset with the simultaneous translation into Ukrainian. Now pass the floor to Miss Maureen O'Connor. Your questions, please.
Good morning.
Good morning.
My first question involves real estate facilities and your wife's joint ownership. Your wife has joint ownership in the following: 1/3, 33.3% of the apartment, and the total square area 58.2 square meters, and 12.5% of the apartment, which is a total of 29.8 square meters. And that is located in the city of Kyiv. Why don't you?
City of Kharkiv, I'm sorry.
Oh, Kharkiv, sorry.
Sorry, I'm sorry.
My bad. Why don't you indicate the co-owners of those apartments in your declaration for 2017 through 2022?
Дякую за ваше запитання. Знову ж таки.
Thank you for your question. I understand that there are technical errors, but I think that my first duty was the complete reflection of all my revenues and all my possessions. I clearly indicated that my wife has this 1/3 of one apartment and 12.5% of the other apartment.
Question is why don't you indicate the co-owners of those apartments in your declaration, not the percentage that your wife has.
Okay.
We understand that, but the co-owners, who are they?
Співвласниками цього
The co-owners are the brother of my wife and my father-in-law, whom I consider my father. So this is the apartment that they have inherited. Unfortunately, my mother-in-law is not here anymore, but so they are the co-owners of this property.
Your wife, her brother, and her father?
Yes.
Okay. And that information should have been included?
Yes, I
Would
understand
you agree with that?
I understand this mistake, yes.
Okay. All right. Moving on. Do you understand the requirement of the anti-corruption legislation regarding the declaration procedure? What's required and the purpose behind it?
Так, я розумію мету і завдання.
Yes, I understand the goal and aim of declaring, as it is fighting corruption. And as of the time that I started filling out, I tried to display all the information. And per the last year, I have shown the income I got abroad from non-residents, from the International Institute for Democracy and Facilitation to the Elections, as the expert of the team Svetlana Mikhanovska for the support of the draft law for the Constitutional Court for the new democratic Belarus. I have shown the electronic declarations, the tax declarations. I voluntarily went and paid taxes, understanding that the organization idea is not the tax agent in my situation. So I have focused on the key income, and I have shown all income, all expenses, all the property that I own, even though there were some technical issues when I was filling in the declaration. So indeed, Yuriy Grigorovich, there were some errors in filling out the declaration, but somehow they're moving from year to year, from 2016, and we have studied 2021. Only in declaration for 2022, there are 6 errors. Yaroslav Mikhailovich, Yuriy Grigorovich, you are a well-educated person, you're a professor, you are pro-rector. Don't you have anyone to consult how to do it correctly? Thank you, Yaroslav Mikhailovich. I noticed most of my mistakes myself. I do not want to convince the advisory group, but have convinced myself I will have to work on this. And please, I would like to draw your attention and say that these mistakes refer to non-liquid assets. Yes, okay, but you have to understand that if you become the judge of the Constitutional Court, the requirements and the careful attention for your candidacy will be a lot higher. And such mistakes in the declaration for the judge of the Constitutional Court are completely unacceptable. I understand this. So I am demonstrating at the moment my honesty and sincerity, independently informing and communicating you about my mistakes without getting additional questions. We don't know whether or not you become the judge of the Constitutional Court, but we advise you to undergo a training, to get some consultancy, yes, from experts who will tell you how to fill out the declaration to avoid such mistakes in the future. I admit my fault. I do not deny it. Okay, I would like to give floor again to my colleague, Madam Maureen O'Connor, and she will ask you another round of questions.
Thank you very much. Now I'm going to draw your attention to your published work, and we have some questions regarding that. In July of 2012, you published an article entitled, quote, "Certain Issues of Consideration of Electoral Disputes by Courts," which became the basis for another article by which you entitled "Certain Issues of Charenting of Electoral Rights of Citizens," which was published in 2014 in co-authorship with your father. And then later in 2016, you published relatively the same article again, which was co-authored with your father. Can you, explain the dynamics of that situation, please?
I was very surprised to hear about the second publication. In 2016, right? I was surprised about this publication. When I took a look at it, it turned out that I was the police colonel and I worked at Kherson University. So the journal legal initiatives, I've never heard about it. I am clarifying this matter now. Why they have reprinted this material, why they have distorted my position, the position of my father, who at that moment already worked in another place. I was not a chief of department, by the way, at that moment. I have also referred to the members of that collegiate, and they were also surprised. So I deny me having anything to do with this publication in the journal in 2016.
Is it possible your father authorized the publication?
Ні, я надав, до речі,
No, I have provided the testimony to the advisory group that at this time my father used to work in another institution and he published with identification of another workplace.
Okay, so let's draw your attention then to the 2014 article. You didn't refer in that article to your earlier 2012 article. Can you explain the lack of reference to one published article and it was not maybe properly identified in the substance in the subsequent article?
I'm sorry, could you clarify what second article do you mean? What's the title of this article?
There 2014 certain issues of charting of electoral rights of citizens. That was the one that was published in 2014. And then in 2012, you published certain issues of consideration of electoral disputes by courts. And apparently, the 2014 article did not
Кримінальне конституційне право.
reference your 2012
Можна підійти?
article.
Я ж не знаю процедури, чи маю я право підходити.
I just don't know the procedure whether or not I was allowed to approach you. Okay, thank you. This is the article that Madam O'Connor just asked you about. Okay, I see. So I assume that maybe they have. So as for the plagiarism, there was nothing in the legislation back then about this. Yes, but there is the notion of the academia integrity back then. This is your material, but you had to refer to it. Okay, I understand. Moreover, this material was not linked to any attestation procedures or scientific projects, and it was not to be reimbursed. It did not presuppose the fee reimbursement. So, so I shall repeat myself. This material had nothing to do with any attestation procedures, with any procedures related to giving the scientific degree or fees to be provided. Lately, I am very attentive to these things, so there is no repetition of this material in any further publications.
That it should have been recognized in the 2014 article? Are you saying that there was no need to recognize it?
I have to study these materials. I can't tell you right away, but having looked at it right now, it seems like, yes, there must have been the reference, but this was my material, so I don't know.
But you are familiar with the concept of self-plagiarism in academia and the need, even if you did publish it, and of course it was your material, if it is referenced in a subsequent article, it should be identified. Would you agree with that?
Ну, звичайно,
Yes. Of course, as of 2017 and until now, I agree with Yaroslav Mikhailovich that such incidents should not take place, although for me it's more of the principal case that I was taught it's plagiarism. I have never done that, and I will never do that.
Have you ever committed, plagiarism? And you're indicating no.
ні.
All right. And then we have the issue of self-plagiarism, which is technically very different than plagiarism, correct?
Yes.
All right. And have there been any other cases in your practice when you have reused scientific material that you've already published without providing references? Is that possible that exists?
Це було, але
It did happen, but until there was a ban by the legislation, so until 2017, when it was recognized as the violation of the academia integrity.
So you have an article, The Experience of Constitutional Reform in Ukraine, in Search of the European Ideal, and that was published in the journal Comparative Constitutional Review in 2014. And it contains a section entitled Constitutional Plots on Legitimacy. Plot 1, What About the People? The text of which was previously published in, quote, the collection of scientific papers, Constitutional and Legal Foundations of Democracy in Russia and Ukraine, and that was published in 2012 by the publishing house Pravo. And apparently there was not a reference from the earlier article to the subsequent article, and appropriately identified as your work from a prior. Do you understand that?
I'm sorry, I didn't catch. Could you please say the year of last publication? 2012.
A comparative article, 2014, contains a reference to what was published in 2012.
Дякую за запитання. Публікація
Thank you for your question. The publication that took place in 2014 in the International Journal of Constitutional Law of the Oxford and Harvard University was a continuation of those speculations that I have laid out in the publication in 2012. I do not deny that I did use certain fragment there, and we're speaking about the years when this was not to be tolerated. But I continued my research, and I published them in the new article. At the same time, I would like to draw the attention of the public that this was a certain narrative about the country aggressor. My last publication was until before the annexation of Crimea. As of that moment, I do not communicate with the Russian colleagues, and I'm not going to. We do not have such information, Igor Grigorievich. Okay, but I heard about Russia, that's why I reacted, sorry.
Constitutional and Legal Foundations of Democracy in Russia and Ukraine, and that was published in 2012.
Yes.
Okay, and so you're saying your 2014 publication was merely an academic continuation of the theories that...
of my research on this issue.
Okay, all right, nothing further.
Шановні колеги,
Dear colleagues, do other experts, members have questions? Vasyl Nikolaevich? Tell me, please, did your wife get dividends from the shares? No, not once. And we did not participate in any general meetings. I see. Are there any other questions? No questions for the candidate? In this case, Yuriy Grigorievich, we're ready to wrap up the interview with you, but since, as of the beginning, we have communicated this to you before we finish the interview, we're giving you the chance to get 5 minutes for your concluding statement. Okay, thank you. I would like to express my gratitude to the advisory group for giving me this chance to participate in this competition. I would like to only comment on a few aspects of my motivation. For more than 20 years of my professional life, I have dedicated to constitutional law. I'm the expert in this area. 15 years out of 20 years, I was trying to facilitate to approve the constitutional jurisprudence in Ukraine, mainly as an expert in the constitutional proceedings. For the last 5 years, I was selected as the chairman of the scientific council at the Constitutional Court of Ukraine. I have certain level of recognition by my colleagues. 2 years ago, I was selected as the first representative from Ukraine for the executive committee of the most powerful and authority union, International Association of Constitutional Law. My motivation lies in me having the certain professional experience. I have a clear understanding and awareness on the necessity of improvement of this official constitutional doctrine that's according to a famous professor, by means of implementation of doctrines, effect, and legislative basis, independent agencies, and most importantly, the chance of implementation of this potential for the protection of the constitutional order, working in the single body of the constitutional justice. Thank you so much. Yuriy Grigorovich, irrelevantly whether you become the judge of the Constitutional Court or not, we would like to wish you to have a more responsible attitude for the declarations, because you should understand what is the aim of declaring the income and expenses for all people who are authorized to fulfill state functions of Ukraine, and on safe plagiarism. You understand me, right? Yes, I do. So, dear colleagues, I announce the interview with the candidate for the position of the judge of the Constitutional Court, Barabash Yuriy over. Thank you, Yuriy Grigorovich. We wish you success. Thank you so much.